If you have all assets joint with another individual, then those assets are going to pass by operation of law to that person. But then that person is free to do with those assets what they will. So if you're married to someone and they get remarried, your assets may wind up being the property of the second spouse. Or if your spouse gets into a car accident and somebody sues the surviving spouse, or if you want to make sure that your children from that marriage, in that example, that the assets return to your children. So those are all things that can be accomplished in a will. And while it's true that sometimes I have married couples who come to me and all the assets are joint, when the first spouse dies, that's true. There's nothing to be done because everything passes by operation of law. But assuming the surviving spouse doesn't change their will, then that person still needs a will. The importance of having the will is that people assume that one person will die and there will be enough time for the second spouse to do a will. But oftentimes there are spouses who are in the same incident or circumstances that render one incapacitated or incapable of making a will, or they have other things to do and they're not going to revisit the plan or even do a will in the first place. And in that circumstance, then the surviving spouse has assets that will pass under intestacy. So that's why it's important to do the plan together if you're a couple, but particularly if you're an individual. Even if all of your assets are joint with another person, that may not be what you want to happen, to have that surviving joint account holder dictate what happens to your share of the assets.